Close, and you're gonna be in layers.
Yeah, I usually, I can.
Oh, you just wanna go on, right? We're just gonna line up, get squishy.
Yeah.
You wanna be in there, go ahead. Sure.
Same.
Step to the side. Yeah, you wanna be in the background? I'm gonna take the picture.
That's where we're.
Yeah.
Good morning, everyone. I'm happy to be joined today with Secretary of State Steve Hobbs and Representative Charlotte Mena. This morning, Washington and Oregon joined together in a lawsuit to stop the president's illegal and unconstitutional attempt to take over administration of our state election systems. Our case is both narrow in focus and broad in its importance. First and foremost, neither the Constitution nor any federal law gives the president authority to set rules for how states conduct elections. Let me just say that again. The president has no authority to set rules for how states conduct their elections. It is the states that decide how voters are registered. It is the states that decide how ballots are counted. It was Washington that decided to adopt vote by mail, which led to us having one of the highest rates of voting in the nation. Democrats and Republicans in our state have worked together to protect and expand participation in our democracy, and Washington has a robust, safe, and secure voting system. But despite the state's very clear authority to run their own voting systems and the clear success of Washington State's program in particular, the president has once again ignored the law by signing an executive order that would give him control over how the states count ballots, what voting equipment states can use, and how states registered voters, and more. The president's illegal executive order violates multiple parts of the Constitution and federal statutes, and the order makes it harder to vote, erodes public confidence in our elections, and makes it more expensive for states to administer our systems. And most alarming, it would disenfranchise hundreds of thousands of Washington residents. The order is so poorly drafted that any state's voting system could be decertified by the federal government. We will not let this attempt to assert control over our constitutional rights go unchecked. But this case is also about a much broader issue. There have been a lot of objections to actions by President Trump, brought by states' attorneys generals, unions, nonprofit groups, and individuals. But it is hard to imagine a subject where this president has less credibility than he does with elections. When the president loses elections, he creates conspiracy theories to explain his loss. He tears down anyone who dares to object to his evidence-free attacks. He has consistently bullied election workers, pressured election officials, and is always looking to undermine faith in our democracy. He is still lying about his loss in the 2020 presidential election. And now he seems to be flirting with the idea of running for an unconstitutional third term as president of this country. American democracy has long been an inspiration for other countries. It has helped lift more voices into participation in democracy. It has given agency to the oppressed, hope to the weary, and a belief that our society can work for everyone. These American values appear to most people, but they are waning in our country, and they are waning in large part because of the actions of the President of the United States. It is highly important that we fight these efforts and not become numb to tyranny. I'm going to turn it over to Secretary of State Steve Hobbs for further remarks.
Thank you, Attorney General. Appreciate that. This executive order by President Trump is the latest in a series of federal actions creating confusion and concern around how elections are ran in this country. For Washington State, this executive order threatens decades of progress and advancements that has made our elections secure, fair, and accessible. In the face of these ongoing challenges, we remain steadfast in our commitment to ensure secure, safe, and accessible elections, requiring all ballots to be received by Election Day for federal elections would have a serious impact on Washington voters, disproportionately affecting rural and underserved communities. In 2024 alone, more than 300,000 ballots were received by county election officials after Election Day. Under this executive order, every one of those votes would have not been counted. Additionally, requiring documentary proof of citizenship to register to vote would harm many eligible voters, especially seniors, low-income people, and naturalized citizens. Many citizens do not have access to these documents like passports or enhanced IDs, making registration contingent on the ability to pay for and obtain specific documents risk disenfranchising voters. Let's be clear. Federal law already prohibits non-citizens from voting, and we already do that. Every voter in our state must attest to their citizenship, and we regularly maintain our voter rolls. The idea of handing over voter rolls for review to the Department of Homeland Security and DOJ, essentially handing over our voter rolls to a billionaire, a group with no election experience and a track record for errors, is foolhardy and ridiculous. And while imposing requirements that make it harder to vote, this administration is simultaneously cutting the very funding and programs that protect elections from foreign interference. These actions leave our election systems more vulnerable to cyber attacks from nation-state actors while sowing public distrust in the process. I oppose any requirement that suppresses eligible voters, and I will continue to protect access to the ballot while protecting the integrity of the process. We oppose requirements that suppress eligible voters that will continue to advocate for inclusive and equitable access to registration while protecting the integrity of the process. The U.S. Constitution guarantees that all qualified voters have a constitutionally protected right to vote and have their votes counted. We will work with the Washington Attorney General Office to defend our constitutional authority and ensure Washington's elections remain secure, fair, and accessible. But it's up to you, the voter, to use that authority to let your federal government representatives know you want our elections to remain the shining example of how easy and accurate and reliable voting in Washington is. Thank you.
Thank you, Secretary Hobbs. Representative Mena.
Thank you and good morning. I'm Representative Charlotte Mena from the 29th Legislative District, and I'm also the chair of our State Government and Tribal Relations Committee overseeing elections and voting rights policy. As representatives of the people, legislators have a duty to move democracy forward, to ensure that every voice is heard, that every vote counts, and that every community sees itself reflected in the halls of power. But our democracy and our ability to make it more accessible is under attack by this administration with this executive order. The progress that the legislature has made to enfranchise voters through various laws, including mail-in voting and automatic voter registration, are under attack. This executive order threatens millions of Washington voters. For me, the fight for voting rights is personal. My parents are Mexican immigrants. I grew up in the city of Pasco, majority Latino population. And despite growing up in an area where everybody looked like me, none of my elected officials did. It made government feel distant, and it made our needs feel insignificant. It wasn't until a federal Voting Rights Act case remedied the voter delusion in Pasco that we started to see a turning of the tide in representation. And we now have a State Voting Rights Act, as well as various other laws that help enfranchise voters. But just like in Pasco, other communities in Washington have endured unjust voting systems and voter suppression, like we're seeing with this executive order. That's what it's intended to do. It's intended to silence voices and make people feel invisible. This is not new. We've seen it before in our country's history, from poll taxes to literacy tests. But the right to vote is given to citizens in the Constitution. It should not depend on how many obstacles you can overcome to cast your ballot. We will defend the progress that our state has made in the legislature, and we will do more to advance voting rights, to expand democracy, to defend the protections that we have, from the Washington Voting Rights Act to language access to voting rights restoration. We'll stand with Attorney General Brown and Secretary Hobbs against this unlawful order today, and we will keep working to strengthen the laws we have now and keep working toward a truly representative democracy. Thank you.
Thank you very much. Let me say a few other things before we take questions. I just want to mention a few other lawsuits that the state is involved in, and including a few additional cases that were filed today. We are co-leading a lawsuit where yesterday we won a temporary restraining order to stop the Secretary Robert Kennedy Jr. from canceling billions of dollars in critical public health grants, including about $160 million to Washington State. Really pleased that a Trump-appointed judge found the courage to issue a temporary restraining order in that case. This morning, we joined another multi-state lawsuit over the administration's
Recording
illegal
in progress.
cancellation of additional grants by the National Institute of Health. This is our second lawsuit in that area. And we're also joining another case with 19 other states to protect a number of small agencies from funding cuts, including museums, libraries, worker rights agencies, and minority businesses. And also this morning, we filed our response in the US Supreme Court to the Trump administration's request to stay the injunction that we received in our birthright citizenship case. We are now part of 11 lawsuits against this administration. And I'm sorry to say at this rate, it is headed. We will have more cases in the future. Happy to take any questions. Sir.
Start off with the voting. When, I'm not familiar with this executive order at all, when did the state receive it? What was the Fed's rationale for it? And Oregon and Washington cannot be the only states with mail-in voting. Have other states with mail-in voting been hit with the same executive order?
Well, the executive order was issued about a couple weeks ago, I believe. And we and Oregon filed a suit today, but 19 other states filed a case yesterday. This case is not just about mail-in voting or how votes are counted or the timing thereof. This case is really about the president's complete disregard for the Constitution. And so a number of states, even those that don't have vote by mail, filed case with California to reaffirm that this is a state function. Our Constitution is fairly clear. Only the Constitution and congressional action can dictate how states set their elections process. The president has no authority. And let me just say that again. The president has absolutely no authority to do what he is purporting to do. We filed a case uniquely with Oregon because of our distinct voting systems that are very similar to Oregon, but a number of states are challenging this order.
What is it about Washington, or I mean, what is it about vote by mail that makes it distinct? I mean, is there distinct legal arguments that are made by Oregon and Washington, based on the fact that we do mail-in voting, or is it just basically another venue? Maybe.
Well, every state is going to be impacted by the order in different ways. And certainly states that are vote by mail and being 100% vote by mail, there are provisions of the order that impact Washington and Oregon distinctly because of the attempts in the order to dictate when a votes have to be received by, how they can be counted. And some of those wouldn't impact states that don't have robust vote by mail systems like Washington does.
A little bit further out how this case differs from the case that was filed with
the claims are very similar, and our system is actually fairly similar to the one that California brought. We wanted to bring our own case because I think some of the harms, if this order was impacted, would impact Washington uniquely. The claims are very similar, but again, some of the states that joined the coalition of state lawsuit yesterday are not going to be impacted in the same way, and we wanted to make sure that we could effectively advocate for our system and the harms that we would face here. We have a question online.
Hey, are you planning to ask for a temporary restraining order in this case as you have for others?
We are not.
And why is that?
Well, we'll move forward with somewhat of a normal process in this case. Temporary restraining orders need to be brought where there's an emergency impact. Because we don't have an election pending in the short term, we did not feel like a TRO was necessary to bring.
Thank you.
John?
I could switch to the NIH lawsuit. This second lawsuit on this matter, how is this different from the first lawsuit? And I read through the latest lawsuit, and it has various appropriations stalled at different parts of the process. Besides the difference between the first lawsuit, how do you know that this is a deliberate stalling or not following through, as opposed to just bureaucracies just move incredibly slow?
Well, I never try to get too far into the head of the Trump administration, so I won't speculate by why they're doing what they're doing. What I do know is that the Congress has authorized certain grant funding by NIH and a number of other agencies. Those statutory delegations of money and authority have very strict rules about how they can be amended, and the president nor his administration simply cannot ignore those. This is different from the first case only in terms of the types of grants it's impacting. The claims are essentially the same as our prior case, but it is part of a consistent pattern by the Trump administration where they disregard the law. They have totally disregarded congressional authority. I'm still shocked on a daily basis that Congress seems quite comfortable abiding their separate independent authority to the president of the United States, and don't appear to put up any guardrails against him. But the general idea is the same as our first lawsuit.
Okay, I'm trying to figure it out. Why is this not a clone of the first?
It impacts a different set of funding that was not part of the first lawsuit.
I have a question. The President has a few weeks on about can you explain a little bit further on the canvas safety mechanism in Washington?
Can you say again that question?
Yeah, the President showed us a few weeks about widespread voter fraud. Can you talk a little bit more about some of the safeguards in Washington?
Yeah, absolutely. One of the things, just let's talk about the VOTWA database, which communicates with other databases and is part of ERIC, which is the Electronic Registration Information Center. So if somebody were to pass away, we will know about it. In fact, in this state, in the primary with the Lands Commissioner race, where we did that recount, we saw some people that had passed away. But the thing is they voted, signed their ballot, and they passed away in between. But that's how accurate our records are. Additionally, we'll know when somebody registers in another state, and we've actually caught people who voted in the same election twice. Unfortunately, people don't know about this, and especially the Trump administration surely didn't know about it, why they're passing this, trying to push this executive order.
Any other questions? All right. Thank you everyone for coming. Appreciate it.
Thank you.
Good work, guys. Everybody breathe out.
Steve. My hair.
I was gonna say,